We just were in court for the Barmore case, so we had, in consultation with defense counsel, were hoping to have the motion filed by the defense to continue the arraignment allowed by the court. The defendant voluntarily gone into counseling. We have just got involved in this case in the latter stages, investigated and been in receipt of various information with respect to the incident. Domestic violence is something I've taken very seriously my whole career, but we have an obligation as a district attorney to review all the evidence. And our review of the evidence is this was not a case we could prove against the defendant. So the goal was, and obviously he's a professional athlete, so it's not the run-of-the-mill case in the sense of, you know, we see this type of these charges often, but he's still entitled to a fair assessment of the evidence, like anybody else. And our assessment was that we couldn't prove the case. We spoke to the victim about the case recently in her position. She's out of state and is not coming back for the case. Not in fear, from what we were told. They have a child together, and you know, he's been taking, you know, obviously providing for the child. And based on additional statements provided by the victim, she had given us an affidavit, we couldn't prosecute the case successfully. So the goal here was, again, he hadn't been arraigned, the arraignment had been continued, and one thing to point out that we are just getting involved in the case at the end. The police investigated the case, we were not involved in it. There was a clerk magistrate's hearing. My understanding is the victim told the clerk magistrate of the police at that time she didn't want to go forward. Now, that happens in many of these cases. And then the complaint issued. So then the complaint essentially is given to the DA's office to handle. And we are under different guidelines, and we have concerns than some of the initial parties who investigate and issue complaints at the clerk's level. So that's what we've tried to do. Deputy DA Soa has been involved investigating the matter. We've received information, as I said, from defense counsel, spoken to the victim, can't prosecute the case successfully. We were hoping to hold it open for a few months so he could continue his counseling, but the court doesn't wanted him arraigned. I guess is suggesting that preferential treatment. Well, he's not getting preferential treatment. I'm looking at the case as I would in any situation. He obviously may have more to lose than other people, given his position, but that has nothing to do in terms of viewing the merits of the case. So, based on the fact the court was going to force him to be arraigned today, what would happen if he was arraigned? I don't know what would happen to him with his position, but ultimately the case would be dismissed. That's what would happen.
What kind of counseling was he getting, and doesn't that show that he did something wrong?
I wouldn't say that. I don't know. I mean, who knows what's going on in people's lives? I don't know anything about him other than he plays for the Patriots. So I don't know what the relationship is, the dynamics of relationships. I mean, we deal with domestic violence cases every day, all the time. This has heightened awareness, obviously, and you're here because he's a professional football player and local team. But we're still compelled to view the case based on our guidelines, which are, if we don't feel we can prove the case at this point, and we clearly don't. I mean, this happened back in August, just because I want you to understand this. It happened in August. It was a delayed complaint. Eventually, the victim said she wanted to go forward. Police applied for a complaint with the clerk's office. He was not arrested, which is significant because in many of these cases it's mandatory arrest. If he was arrested, he would have been arraigned, so he wasn't arrested. And he's presenting here now 7 months later, and the circumstances have changed. I think the court was concerned that, well, I'm going to give this guy preferential treatment by not arraigning him. Well, they get arrested in most cases, and that's how it goes. They get arraigned, and we react. We're not there at every case saying we don't want him arraigned. Some of these cases are terrible cases. So, and again, I've been very tough on domestic violence my whole career, which is almost 30 years, but we also have to be fair to the evidence. And I think that's what happened. So it would have been preferable for the court to say, okay, we'll hold out the arraignment for 3 months. If he had no further issues, it's like a pre-arraignment diversion is what I was trying to do, as opposed to a post-arrest diversion. But ultimately, if you can't prove the case, you have to...
Did his status as an NFL player play any role in the way this has been handled over all these weeks and months?
Well, I mean... Well, he's obviously not the run-of-the-mill person. I want you to understand, most of these people are arrested. If I'm accused of assaulting my wife, they're going to come and arrest me. And she says, don't arrest them, let them... No.
So why wasn't he arrested?
I don't know. Well, it was a delayed complaint, and the victim had mixed emotions about whether she wanted to go forward. So at that point, I think it's appropriate. If it doesn't, because we're talking about the right of arrest when it's promptly reported. You see what I'm saying?
Yeah.
And there's an immediate arrest for obvious reasons. If they say, okay, we'll summons them in, and then the person gets murdered, then that's people are in trouble.
The case would have taken a different track if he was arrested.
Well, not from an evidence point of view. I think all I can say is you sat there, the court, if we can't prove the case in the end, in this respect, the evidence of what happened, the victim says she's not coming back from out of state. Now, we could attempt to force her back. I don't think we do that in this. We could attempt to say you're going to come back. However, we're considering her statements and the evidence. And even if she came back, we're not going to win this case.
Do you have any
So
message?
is her
Do you
not
have any
being
message
willing
to
to come
Christian
back?
Barmore? Do you have any message to Christian Barmore as he goes forward in his career now that the case has been dropped?
Yes, the message is he's got a lot on the line here. He has a professional contract. He's got the ability to provide for his family, and he's very fortunate, the position that he's been in. And he was drafted. So now he's on the team. I don't know what the status is, but I told the line if I was Christian Barmore.
DA, was the victim not being willing to come back the straw that broke the case, or even if she had come and testified, you think he would have lost?
Well, I don't want to... These cases are very difficult to prosecute. I've been involved in the prosecution of thousands of these cases. If you have a victim, I'm speaking generally here, I want to be respectful towards her. We've had a positive conversation, but these are the dynamics involved in domestic violence cases are complicated. They're not simple. In many cases, the victim does not want to go forward after the fact, whether it's a day after the arrest, 2 months after the arrest, whether they're unduly influenced by people. I'm not saying that's the case here, but these cases have a pattern. So we have to have credible evidence to go forward. I've seen many cases go to trial that I thought there should be convictions. Far stronger than this case, they're acquittals by a jury. Now, it doesn't mean you can't bring them to trial. We bring these types of cases to trial often, but here are the facts and circumstances. The case is brought to our attention after as I've explained, the case was reported 10 or 12 days later. Eventually, Mansfield applied for a complaint. Complaint was issued by a clerk. We're not involved in this at all at this point. They issue a complaint. Then the information is given to us, and now it's 7 months later. So the case is in a different posture or position than most cases. You understand what I'm saying? They'd be arrested, so somebody could say, I want to drop the charges that day. Well, we move on because it's the heat of the moment. Now we're reviewing it. The guy does have a lot on the line. So, I mean, I'm going to potentially do the same thing in a case later this week, in an insignificant, trivial case. Why? Because someone has brought to my attention what happened. Okay, it's a younger person, no status, no nothing. So if facts are brought to my attention, as I've done my entire career, I consider them because I think that's my duty and job. And I don't see any reason why the judge couldn't have said, okay, we'll hold the case open. It's not even so much the counseling. He did it voluntarily, but let him be counseling. Let him behave himself. If he can. I mean, again, the guy has a lot on the line. It's not always a professional athlete. He is. And that's given him an opportunity to have a life for himself. So I hope he can make the most of it.
At what point did the victim become uncooperative?
I would say uncooperative. I would say is a process that's going on. Again, this isn't This is 7 months now, right? From August, is that right? I mean, this is the beginning. So, she's made some statements. She's indicated she moved out of state. Again, this is before we're even involved in the case. And has indicated to the police department, I'm told, before the clerk's hearing, to our office, she's filed a document, provided a document to us that we've reviewed and put in the context of the entire case, and says, I'm not coming back, and we feel that the evidence, you can use different terms, the case could be compromised in the sense that we don't think we can prove it, which is the case. Now, there are a lot of cases like that. Again, the court, I understand the court basically saying, hey, this is a pro football player, I'm not dismissing the case. That's what it comes down to. So, I'm standing here, and I'm the one taking action. That's my job and my duty, and I'm calling it as I see it, which is, I think this is the appropriate result. It doesn't mean Christian Barmore is a great guy for what may or may not have happened. I hope he can move forward with his life.
Some of our businesses, it sounds like they're going to move on together. It sounds like with the victim, Barmore and victim.
I don't know if they're remaining together. I don't know the specifics of the relationship. I'm told she's out of state. We spoke to her. Our understanding is she's out of state. There's a child involved. The family.
A factual clarification on the child. I'm sorry, but according to the complaint, when this happened, she was 7 weeks pregnant. That would make her nearly due with the second child. Do you have any information on that?
I do not. I don't. I do not.
You don't know if she's still pregnant.
I don't know the circumstances of that, but I think
And if I can just state,
Sure.
there is confidentiality surrounding domestic violence victims, so I just want to make sure that we're all mindful of that as we talk about, obviously the DA is referencing a changed circumstance, but there's confidentiality surrounding those particular victims.
So, in the end, it comes down to reviewing the case. I understand the court. This is the process, basically saying, I'm not continuing the arraignment. That's what happened, right? Were you there? Okay, so DA, drop the case. What is frustrating a little bit from my point is, we're the last ones to be informed about the case, but it falls on the DA, which is part of my job. We accept it. But I'm just saying that's a little frustrating to me, because maybe a complaint wouldn't have been applied for. Maybe it would have. Again, these are delicate cases. There's volatility. There's recantations for a variety of reasons. And that's how it played out. The easy thing to do would have been arraign them, right? Should have arraigned them and then come waltzing in, and 7 months from now the case would be dropped. That's what would have happened. That's what the clear odds are. Now, she could have said, I've had a change of heart, I want to go forward, and in my opinion, which has been, based on a lot of experience, we couldn't win the case.
Bottom line is it's case closed.
Yes.
That's simple.
Case closed in the method that it happened. That's what I'm trying to explain. But yes, the case is closed as of tomorrow.
And no arraignment, so he was never actually charged officially by the court.
He was not officially charged, and that was the issue, because the court wanted him officially charged because, I think that preferential treatment, right? That's what it's all about. And I'm not giving him preferential treatment. I'm considering he's got a lot on the line, but we can't prove the case. To have the case go forward now would just be form over substance to me, if you understand what I'm saying.
So it's safe to say you kind of wanted the arraignment hanging over his head, for lack of better terms, so that he continued to seek counseling, but the judge was not going to go for that.
The judge did not want to continue the arraignment you couldn't hear, I couldn't hear it either, but I'm told, because she doesn't want to say I'm dismissing the case because it's an NFL player. So the DA, the alternative is to null process, and that's what happened. Okay, thank you.